Self-defense is a big issue here in the state of Florida and probably everywhere in the country. There isn't a lot of clear guidance in terms of what is self-defense, what is legal, what isn't legal. And I want to talk to you today about a recent case of Cohen's v. the state of Florida. And Cohen's is spelled C-O-W-I-N-S. And he was found guilty of second-degree murder. Self-defense became an issue because Cohen suffers from PTSD. And the defense attorneys had an expert ready to testify at trial to say, look, he suffers from PTSD, which then impacts the testimony regarding his self-defense. His perceptions of what is going to be a threat are going to be different than you and I's perceptions because he has this post-traumatic stress disorder that will impact how he views incoming threats, right? And the court said, no way, we are not letting an expert talk about PTSD and how that might have impacted self-defense. We're not going to allow it. Now, I want to start at the basics here. What is self-defense, right? In Florida, I'm going to read to you what we've got under Florida law for self-defense. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. Notice what I left out of the self-defense law because it's not law. You cannot use deadly force to, protect your brand new e-bike, right? You can't. Sorry. Or you love this car and you want to prevent somebody from scratching it or whatever. That's not in the self-defense law. Okay? Not using deadly force anyway. I want to tell you what the problem is with defending Cohen's case, having an expert ready to testify about PTSD and why that was denied. And that is a controversial decision, but let me talk about the self-defense instruction because it plays off of Florida law. And by understanding what the jury was read in terms of saying, you can find that this person did not commit a crime and defended themselves legally, here's the instruction. In deciding whether the defendant was justified in the use or threatened use of deadly force, you must consider the circumstances by which he or she was surrounded at the time the force or threat of force was used. The danger need not have been actual. That's important. However, to justify the use or threatened use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force or threat of force. Based upon appearances, defendant must have actually believed that that danger was real. That's the instruction that the jury has read. Now you're going to ask yourself, you just read me a whole bunch of stuff that seems to say that PTSD would be an important thing for the jury to know. No, because it all goes back to self-defense is not about you. It's not about how you were feeling. It's not about how I was feeling. It is about whether an objectively reasonable person under those circumstances would have felt that danger. Whether the danger is actual or not, whether a reasonable person in that spot would have felt that way. Not whether you would have felt that way with PTSD. That's what the court is saying. Here's the quirk. The quirk is, this is a 4th District Court of Appeal decision that just came out in Cohen. It is in direct conflict with Mizell, M-I-Z-E-L-L. Yeah, M-I-Z-E-L-L. This is out of the 1st District. The 1st District has flatly said, heck yeah, bring in the PTSD information because that comes into play in all that stuff I just read you. You're talking about the perceptions of the person that used or threatened to use deadly force in self-defense, and yet you don't want to talk about their perceptions. So this is not resolved yet. You have this decision that says, nope, PTSD does not come into it. What that defendant felt doesn't matter. It's what a reasonable person in those circumstances feels. And the first district said, no, this is relevant and we're letting it in. I don't know when this conflict's going to be resolved, but I'm just keeping you updated on self-defense so you have a better understanding of just how cloudy and murky self-defense is in Florida. I mean, not even the courts can agree on self-defense here in Florida. So my best suggestion for you, of course, is if it happened, anything like this happened in Central Florida. I've been defending cases for 31 years here. I hope that you'll give us a call. We'd be happy to help you out. And thanks for watching.